Thank you, Father. Thank you, MEMON Professional Forum, for inviting me here. Of MEMON community towards the city of Karachi, which is the backbone of this country, is tremendous. And in my progress in profession, it's also tremendous. More than 80% of my clientele is MEMONs. And because of that, I can speak a bit of MEMON, Gujarati as well. I love the way they carry themselves, subdued, humble, even though they're full of billions of rupees. May Allah give them more and be part of our society. Now start with the paper, or I introduce myself, whatever is convenient with you. I started my practice in the year 1990, graduated from SM Law College, joined Mr. Munir Malik. That was the first and the last office I joined as junior. He guided me through the profession. And there's one more person whose son is here. He guided me through the property law, Mr. Yaqub Kabadi. Very humble, rough, but honest. And still, if I need some guidance, I call him, Yaqub Bhai. And now he turns me to his son, Mr. Wes Kabadia. I still have emails of the problems he solved for me. Now comes to the judicial system. अब मेरे पास कोई हाई कोर्ट का क्लाइंट आता है और वो केस दे रहा होता है, तो मुझसे पूछता है सिविल सूट में कि ज़िया साहब इसका फैसला कब होगा। मैं कहता हूँ ना मेरी ज़िंदगी में होना है ना तुम्हारी ज़िंदगी में होना है। Our judicial system is choking day by day, especially the civil system. My friends who comes to the High Court, they witness this. Now we take case and file only for the stay order. And if we are lucky, we get a stay order. If we are for the defendant and there is a stay order, we tell our client it will take at least 2-3 years to get the hearing of the application. And if we are unlucky, we still don't get the hearing of our applications. Sometimes the next date is after 2 years. That is the dilemma. It is not in the history of judicial system that such stages come. First of all, most of you knows the reason, but some of you don't. Our judicial system is based on Islamic judicial concept, but it is not court of justice. Our courts are not court of justice, neither they are court of equity. They are court of law. You have to understand this. Our courts are neither courts of justice nor courts of equity. They are courts of laws. Meaning thereby, sometime the judge knowing fully well that our client is guilty, knowing fully well that our client deserves the relief, but due to the judicial complexity, he refused such relief. Our judicial system is so complex that, especially the civil one, the law says when the evidence starts, it will finish and immediately there shall be arguments. But since there are so many cases in our courts, even the evidence of one witness take place in several intervals comprising of months and years. It's neither the judge, nor the lawyer, nor the witness remembers what he said on the last evidence. There was a reason why the law says that the evidence shall be start recording and it will finish and immediately there shall be arguments of the parties. When a judge record witnesses' evidence, then he knows, he remembers the testimony, he knows the reactions of the witnesses, he knows what were they saying, how they were saying. Then there is only a few minutes job to hear the arguments and write the judgments. Only once in my lifetime happened this in the High Court of Sindh. There was a case and Mr. Justice Arif Khalji was there. He called the witnesses, one witness, two witnesses, three witnesses. After third witness, he said arguments. And before hearing that, he tell the plaintiff, listen, if you want to settle, you settle it, otherwise I'll give a judgment today. That was settled. Because the witness knew what he has said and he knew that judge has noticed everything. But when you have heard the arguments or part arguments and you do not know when the witness evidence was recorded, you can't do that. The next problem is there are so many requirements which has to be fulfilled in a civil judicial system for the judgment. And even there's a one lapse, then the case is remanded back. Due to this reason, and even now there is a Article 10A in the Constitution. It says right to fair trial. And even in banking cases, it was argued that the right to fair trial does not mean that the leave shouldn't be granted. It should be granted because it's a fair trial. And when the leave is refused, there's no trial. Same situation happened in England as far back in the year 1994 and prior to that. There was a judge who was appointed. His name was Lord Wolfe. He was appointed as judge in the year 1994. He was given a task how to revisionize the judicial system in the UK. He gave a report and that was acted upon. In 1998, there was a revolution in judicial history in England, and it is known as Lord Wolfe Revolution. He rewrote the CPC, which is called White Book in England. And he redesigned the entire judicial system. Now, at the lower level in England, you have to fill only the form. You fill the form, write a statement, file the case. That's all. And the judge has to decide. Because in England, it cannot be conceived very often that the witness will tell a lie, which is otherwise in our country, we know all. Then in the cases of High Court, he introduced cost system, which is not here in our judicial system. And that was very, very unique and different. The whosoever file a case, first he has to deposit the cost of the other side. Then, if he wins the case, he will get the cost of his lawyer as well. Okay? In our society, in our legal system, if you get cost, that is 2 rupees 50 paisa for the plaintiff, and lawyer cost we don't allow normally. And most of the lawyers don't pay tax, so they don't, unless it's from the company fee, they don't show it. The cost system he introduced, he said, I file a case as a plaintiff and the defendants come forward, case is being proceeded, and at one stage he offers me a settlement, like say my claim was £100,000 and he offers me a settlement of £20,000 and the plaintiff refuses. Then after 20,000, after that date, the proceedings take place and the case is finally decided by the court. And if the court decide claim of £20,000, then from that date till the decision will go to the cost to the plaintiff. He has to pay the cost of the other side because they made a fair offer of settlement. I hope you guys are getting me. That system put a hold to frivolous litigations in the UK. Then he introduced to ADR. Now we all know what is ADR, Alternate Dispute Resolution System. In Pakistan and rest of the world, firstly there was an Alternate Dispute Resolution System was 1940 or 1937 Arbitration Act, which failed. In our country, it's absolutely failed. Otherwise, if it could have been acted upon, as it is working in other part of the world, it would have been very, very good system. The system is, they will appoint an arbitrator, sole arbitrator or an umpire. They will decide in 4 months there shall be evidence, and then they file their award, and the award has to be heard, and objection to award, if any, has to be heard in summarily manner. But due to the backlog in our High Court, this take about 20 years. Hearing of objection to award, then appeal, then... So this system failed. Now, in England, about 25 years ago, they have introduced another system which is working. That system is called mediation, and it helps if the parties are really wants to decide their dispute ASAP, then it helps. They go to they appoint their mediators and they join the session. It takes 1 or 2 days and the dispute is over once for all. Unlike the arbitration award, since the mediation is between the parties as they agree to the terms and conditions, so there is no further proceedings in those. In our CPC, Section 89 is introduced for that purpose. But unlike England, this mediation did not take off here. And the very simple reason is the cost. Sometimes we file litigation just for the sake of it, because the party knows he will not get a judgment, but he has to pay only 15,000 rupees and a lawyer fee, and everybody is not rich enough to afford Mr. Khalik or Mr. Khalid. They appoint lawyers for me. So I take 50,000 rupees total, including the court fee. Sometimes the litigation is initiated to delay some process. Their purpose is not to get the dispute settled. Their purpose is only to delay things. Like if somebody is taking contract and he has got a stay order, he will try to prolong it. He will never come to the table. And one more thing, our society, I'm also part of it, they file frivolous litigation, they swear false affidavits, they tell untrue things, and they are not caught. They go scot-free. This is the reason they do not come for settlement, because they know the time it takes, nobody will know what will happen after 20 years, 25 years. I'm handling a case, 1985. It's fixed for arguments. Facts are very simple. My client supplied water in the year 1985. So, Karachi Water and Sewerage guy asked his share. He did not give. Suit is filed. Everything is admitted, but it's lingering on. It was reserved in 2015. Then the learned judge, after 3 years, sent the file back for rehearing. It happens every day. Mr. Khalid knows, and whoever's practiced in High Court, he knows this happens. So it's still going on. We don't know when it will be finished. The solution for all these matters is, number one, we have to simplify the civil procedure code, and we should give training to the judges how to implement this. Number two, there is an office of registrar in High Court, additional registrar, original side. The officer should be well trained for civil procedure code. So he should know how the suit should be processed. Number three, the civil procedure code should be simplified, that a common man can understand. Now our legal language is, sometimes we, unlike Mr. Khalik, we have to, then this should be cost-effective system. The person who is losing has to pay the cost, and the big cost. This is the only way we can halt frivolous litigations in the court. Then the judges. In High Court, no judge has time to record evidence. Last time I seen proper evidence being recorded in the High Court of Sindh, that was in 1992. There was a case of damages regarding defamation suit. That was the last time the evidence, proper evidence, or I recorded in 1994 the suit I. They should appoint at least 20 retired district judges and senior lawyers to record evidence. Then the learned judges on original side, nowadays there are 5 or 6. There should be at least 25 judges with 5 cases only. Nowadays, about 50 regular hearing, mean argument cases, are fixed before one judge. There is only one judge for regular hearing, and he has 50 files a day. He spends his whole time by giving dates. If there shall be 5 cases before him, at least one case would proceed. So the cases should be less, and the judges should be given tasks to proceed and decide. In the year 2015, the Supreme Court has given judgment which says the lower court judge should decide the case within 30 days, the High Court within 90 days, and the Supreme Court with no time. Decide mean not the filing. After hearing the case, you should give judgment in the 90 days. This is also not being followed. It should be followed strictly, and reports should be submitted with the Chief Justice of Pakistan regularly. Only then the system can improve. Otherwise, we should go and find some other work, because the client will not come And they still don't come. If they know after 20 years, what will I do? A 20 year is a shorter time. Yes. Any question? I'm open to it.
Is this model code has been introduced? Do you think it will work or not?
The model courts are still not introduced in High Court. There are two sayings: justice delayed, justice denied, and the justice hurried, justice buried. So there should be some midway. I appeared in a model court, lower court, in an appeal. There are no model courts as a trial court. If there is suits के लिए, there is no model court. There is a model court for civil cases on appellate side. What they do is they decide the case within 1 month. And they always decide in the favor of respondent. That is the problem. Why? To agree with you, I have to say yes. To disagree with you, I have to come up with reasons in law. So what they do is, they rewrite the judgment, and in last 4 lines, they say they do not make any claim. Appellant failed to make any case for interference the judgment, hence the appeal is dismissed. Model courts are not with the process or procedure. We need model judges. We have few judges in High Court. We call them model judges. We have strength about 40 judges at the moment. And if you divide by 8, we have those judges who work, if you want. And you should be proud. The MEMON Professional Forum should be proud. There's one. We are lucky to have one judge, and he is so quick, is so good at law. लगता ही नहीं है MEMON है. Yes, sir.
Regarding the monetary jurisdiction, there is a monetary jurisdiction in Karachi as compared to other countries. In all over Pakistan, there is unlimited jurisdiction. In Karachi, there is only 150 crores. Do you think that in Karachi, in High Court, there is a unlimited jurisdiction? I think then justice may be solved.
That's a very, very good question. The monetary jurisdiction of High Court of Sindh Karachi bench has a historical fact. And there's a case law on that. Since Karachi was a port city and it has potential of business, that is why, especially in Karachi, this jurisdiction was given to the High Court. As a lawyer, I would love to that my cases should be decided in 2-3 years, which is done at the lower court. But I choose not to file any case in lower court unless I cannot avoid. My brother came, he has to file a case. I say yes, chalo, try karte hain, file karte hain. I filed the case in lower court. Then my associate called me, the judge is calling. It took me 1.5 hours to convince the judge that this suit is maintainable for the admission of the case. But I was unable to persuade him. And he said, you have to change these 2 paragraphs. And my junior told me, sir, ये इसे change कर दे, कोई फर्क नहीं पड़ता. This is one of the reasons I don't file case in your court. The second, when a client came, he needs some injunctive relief from the court, which is impossible in the lower court. I had chance to meet with certain judges and had discussion over it. And they agreed. I said, you gave proper training to the judges of lower courts. Tell them they can give relief, they can give injunction. If I can get injunction in lower court at my convenience, then I will not file case in high court. I get my case decided. Well, high court में you have to wait for your turn of the case. फिर बारी आती है नहीं आती. लोअर कोर्ट में तो सुबह जाके वो टाइम रख देते हैं ना, 10:30 बजे 11:30 बजे तेरा हो सकता है ना. तो unless our lower judiciary is given power to grant stay, which they have, they should be informed you can, or they should be given training before the judges of the high court on a regional side wo aake baithe. One thing I have to admit, the judges of Lahore High Court, the lower judiciary, Peshawar High Court, Peshawar Court, civil judges, they have good writing skills. हमने यहाँ जजेस की तनख्वाहें तो बढ़ा दी, उनका मेयार नहीं बढ़ाया. I had a colleague from Lahore, still works with me. He used to travel every day from Lahore, Multan, Peshawar, Pindi. जानते होंगे मोइन कमर, he was a IP lawyer. तो वहाँ तो आपने जैसे कहा लोअर जुडिशरी में होता है. मैंने उनसे पूछा, मैंने कहा यार व्हाट इज़ द डिफरेंस. मैंने कहा वहाँ लोअर जुडिशरी में स्टे मिल जाता है. इसे इंजंक्शन इज अ रूटीन, नॉट गेटिंग इज एन एक्सेप्शन. इस कमरे में कोई ये बता दे कि विदाउट नोटिस लोअर जुडिशरी में कोई स्टे देता है. जब मुझे स्टे ही नहीं मिलता तो मैं हाई कोर्ट आऊँगा ना. दैट इज़ द रीज़न. लकीली वी हैव हाई कोर्ट. हाँ जी. एनी अदर क्वेश्चन?
Very define about the issues and your recommendations how to make a speedy trial. And definitely ये जो recommendation आपकी different forum से आप वही सर्विस देती हैं. तो उस पर कोई hearing या कोई attention या कोई इस पे who is taking care of Ministry of Law,
Ministry
the
of
government or Supreme Court?
जिस तरह हमारा जुडिशियल सिस्टम है ना, इस तरह पूरे मुल्क का सिस्टम है. लेकिन इस वक्त इस मुल्क का एक बहुत अच्छा वकील, आप उनसे सियासी इख्तलाफ तो कोई भी कर सकता है, लेकिन उनकी इंटेग्रिटी, नॉलेज पे सबका कंसेंसस है. फ़रूक नसीम साहब वो इस पे काम कर रहे हैं. और वो नया सिविल प्रोसीजर कोड उन्होंने बना लिया है और जल्दी ही आ जाएगा, जिससे थोड़ी सिस्टम में बेहतरी होगी। जो मैंने उनकी एक जगह सुना था, वो कह रहे थे कि सिविल केस जो है 2 साल में डिसाइड हो जाएगा फ्रॉम ऑल स्टेजेस, एंड फॉर ऑल स्टेजेस मीन अ ट्रायल स्टेज, appellate stage, and the stage before Supreme Court. That is in America. There is a system in Supreme Court. उनके बहुत ही केसेस होते हैं। जो भी सुप्रीम कोर्ट में पिटिशन फाइल होती है, हाई कोर्ट की जजमेंट के ख़िलाफ़ अपील फाइल होती है, वो चैम्बर्स में चली जाती है सबके, और वो चैम्बर में उसे जजमेंट को पढ़ते हैं, उसके ग्राउंड्स ऑफ अपील पढ़ते हैं, और अगर 8 में से 5 जजेस ये कह देते हैं कि इस पे लीव ग्रांट करके इसे सुना जाए, तो वो कोर्ट में लगती है। अगर 5 से कम कहते हैं तो वो वहीं फारिग हो जाती है। यहाँ भी ये प्रपोज़ल आया था सुप्रीम कोर्ट में कि लीव बेशक कोर्ट में सुनी जाए, लेकिन अगर लीव ग्रांट नहीं होती, इसके लिए इस वक्त ये सिस्टम है कि सुप्रीम कोर्ट में वो प्रॉपर ऑर्डर देता है कि ये रेज़ हुआ, ये रेज़ हुआ, और उसका ऑर्डर आता है, फिर एक खलीक साहब रिव्यू फाइल कर देते हैं। तो उन्होंने कहा था अगर लीव ग्रांट नहीं करते तो सिंपल होना चाहिए लीव रिफ्यूज़, तो उससे ना जज का भी टाइम बच जाएगा और रिव्यू का भी टाइम बच जाएगा। ये रिव्यू तो उसी वक्त होगा ना, क्या नहीं पड़ा। तो ये है। एनी अदर क्वेश्चन? थैंक यू वेरी मच सर, इट्स अ प्लेजर टू बी अराउंड यू। थैंक यू।